Don't forget recording. Yeah.
Hello all, welcome to ILA Dialogues. Today we have with us Advocate Amit Karkhanis. Amit has been practicing for almost 2 decades with a rich experience in medico-legal laws, surrogacy, healthcare sector, and intellectual property rights. Amit is a renowned medico-legal expert and was one of the foremost lawyers to practice medico-legal laws and surrogacy in India. He holds a Master of Law degree in International Trade from University of Newcastle upon Tyne, United Kingdom. Amit has represented the Joint Committee of the Parliament to review and draft the surrogacy laws in India. Amit has also been involved in the Sion baby theft case, wherein a landmark judgment, the High Court Mumbai, has put forward several guidelines to be implemented in municipal-run semi-government and government hospitals all over Maharashtra. Welcome, sir. We're really glad to have you today. Today, sir, we'll be speaking on product liability under the Consumer Protection Act 2019.
Thank you, Sudisha. Thank you, Jamshed, and thank you, ILA, for inviting me to speak today. And it's really a pleasure to speak on the topic, which is close to my heart. And thank you for opportunity. And I will start now. Can I just start?
Yes, sir. I have shared the screen.
Okay. So is this visible, Sudisha? Can I?
Yes.
Can you
yes.
please all see this? Okay.
Yes.
Today we have when Sudisha called me up to ask me what would I like to speak, I selected this topic for a simple reason, is because this is something which is newly passed by the government, this new Consumer Protection Act 2019, which came into effect from 20th of July 2020, and the government notified the rules, and even the mediation rules, court rules, all the rules have now been notified. So this act has become a full-fledged law now. And one of the unique features, there are many features in this act, and I didn't want to take the entire act, because there are a lot of parts in the acts which are very unique. And one of the things which I thought would stand out in this day and age of consumerism is the product liability, which the new Consumer Protection Act deals with. So we're not going to deal with so many things, don't worry, because my actual presentation is much larger, because when I speak about product liability, I have to take to everything, but due to the paucity of time, here we will take some of the key elements. So as lawyers and as students of law, we all have studied this first principle, and which is famous traditional rule of Caveat Emptor, where we all used to say that let the buyer be aware. And, so that's that put the entire onus on the buyer, to actually be careful as to when he buys the particular product or service. So now this rule of Caveat Emptor is no more applicable, and the burden has now shifted onto the seller. So the traditional rule, with this rule of Caveat Emptor, we have studied in the Sale of Goods Act, and now it is no more applicable, and it has been with the new Consumer Act, now all the sellers, the intermediaries, and and even the service providers, all have been brought into the ambit of product and service liability. So the 2019 Consumer Protection Act provides for protection of interest of consumers. So there are a lot of unique things in these acts, not only protection of consumers, but also establishment of Consumer Protection Authority, mechanism to settle disputes. Now, over and above the product liability, which we will see in this presentation, another mechanism that the government has set up under this act is that mediation centers are now to be established at all the district forums and state commissions and even national commissions. So every court will have a mediation center, like family courts, where mediation is also promoted, where you have counselors, and even in all the district courts you have mediation centers. Even in the High Court we have mediation center. So the same way now consumer courts will also have, they are hoping that people would actually take advantage of this mediation centers and try and go for mediation. But not every case can go for mediation. So the mediation rules that have been notified clearly keeps out medico legal cases or medical negligence cases which are filed against the hospitals and doctors. So you cannot take a medical negligence case before a mediation. So there is a list of a lot of other things also, but nevertheless a normal complaint against a manufacturer or a intermediary or a seller can actually go and you can actually have some sort of a settlement out of court. And needless to say, product liability is also now part of the Consumer Act. Another interesting thing is that they have also added the section on unfair trade practices, where we see a lot of companies indulging into advertisement which are false and misleading. Though we have an agency called Advertisement Council of India, but it's a toothless lion, and they don't have much of the powers to other than issuing notice. They don't have much of the powers. So now the new Consumer Protection Act has given a lot of teeth to this unfair trade practice aspect also. So all in all, the act has tried to cover a lot of spectrum of consumer movement, and they have tried to codify the traditional law of torts, and try and give it a legal shape. Because lot of in the old 1986 law, there were a lot of aspects which were not covered, and we'll see how this has changed now. So the new section 34 of the Consumer Protection Act defines product liability. Now the definition is quite broad in its sense. It says that the responsibility defines product liability as the responsibility of the product manufacturer. Now there are some keywords which I would like to highlight here. Responsibility of the product manufacturer or product seller of any product or service to compensate for any harm caused to a consumer by such defective product manufactured or sold, or by deficiency in service relating thereto. So now if you see, this definition covers product manufacturer also, and it covers product seller also, and it also covers the services also. And in the end, if you see, it says that defective product manufactured, sold, or deficiency in service. So now if you remember, most of the times if you go and buy a product from a shop, and if the product is defective, the shop owner used to always blame the manufacturer, because he used to say that I don't manufacture these products, it is the manufacturer who manufactures this. So that's why the intermediary, the actual seller of the product, was never held accountable. Well, obviously, as part of the consumerism, lot of shops used to refund you the money, or exchange the products. That practice is still prevalent even in a small kirana store that you go. For example, if you buy something from a kirana store and if it is spoiled, he will just replace it for you. But what happens if you actually go to and buy something from an intermediary seller, and he doesn't return the good to you, or he doesn't compensate you, or if you suffer some sort of a bodily harm, if you consume something, or if you use a product? So at that point of time, there was absolutely nothing which could nail some sort of a liability on this intermediary. So now, product manufacturer per se were always liable under the Consumer Protection Act even before. I'm not saying that this is totally a new concept, but they were not liable under product liability section. They were liable under deficiency of service. So or deficiency or of product, so that is where they were tried to, it was hence it was becoming very difficult for the consumers to actually pinpoint the liability. And this section 34 has now eased that difficulty of a consumer. And needless to say, service providers have also been included. So now if you see service providers, which means everyone who is into product giving of services will come into it. Doctors, architects, any sort of consultants or professionals, all of them would be now covered under this definition. So I'm not sure how long we lawyers will remain out of the scope and ambit of this, but I'm sure it's not soon, it's not if not now, but in near future, I'm quite sure that even the legal profession and the lawyers, especially law firms, will come into the ambits of service providers. Though personally speaking, I don't want to come into that, but still it's not my choice. So now if you see, I'm just going to take these two definitions. I'm not going to go into too much of definitions. So section 34 is the product liability definition. Section 35 is a section which defines what is action, product liability action. And it says it means a complaint filed by a person before district commission or state commission or national commission, as the case may be, for claiming compensation for harm caused to him. So now you can see that depending on the amount of compensation that you are claiming, you can go and file a case before a district commission, state commission, or a national commission. That is the claim, or the damages that you are claiming will decide upon the jurisdiction of the commission. So this is something which is very easy to understand. Now, what is the goal? Why do we why do I say that it is something which is good for the consumers? Obviously, the goal of the product liability law is to help protect consumers from dangerous and defective products, while holding manufacturers, distributors, and retailers responsible for putting into marketplace products that they know or should have known were dangerous or defective. So it's all about accountability. It's all about transparency. So nothing prevented you from going into an ordinary civil court and filing a civil suit for damages. But consumer forums are meant for consumers. They have a speedy mechanism prescribed under the law. It is a summary trial. It's a summary court. So hence going and suing a product manufacturer for a defective product in a regular civil court or a suit for damages would have taken years together. So that's why consumer movement was started in India, and the Consumer Protection Act of 1986 was passed. Subsequently, as the economy grew and as consumerism grew, it was felt that consumers were unduly targeted, and there were the 86 and 96. In this 10 years also things changed. So it took a long time for the government to actually change the old acts. In 1986, we never had internet. So at that point of time, that act did not vision the kind of online transactions or e-commerce selling that happens right now. So hence the new law is very handy. It has now also included the transactions pertaining to e-commerce and online. Earlier, that was very difficult because the definition of consumer did not include buying and selling of products or services online. But now it has very clearly mentioned that even online services and products are included as consumers. So that's why it again helps a lot it again helps a lot to the consumers. Now, very briefly, obviously, the consumer movement has its origin in US, because you can see, I'm sure you hear a lot of, suits, high value suits that are filed in United States. So, it first started in 1963, by the Greenman decision. And then subsequently, in United States, this thing really picked up. And the kind of accountability that they have as far as the description of the products or as far as the quality control, it's tremendous. And they have a very robust mechanism to deal with such type of defective manufacturing products. Obviously, the service sector in United States still remains to be effectively governed, but as far as manufacturing sector is concerned, they do have a very robust mechanism. So prior to the Consumer Protection Act 2019, there was no specific product liability theory in India. So, so like I said, I started off by, the doctrine of, Caveat Emptor, that let the buyer be aware. This was a predominant rule in India, that the onus was put upon the buyers and not on the sellers. So it was the buyer who had to take care, the seller used to go scot-free. That's the reason why the new act, I feel, is a landmark provision. in the absence of statutory law, courts were guided by principle of justice, equity, good conscience, which means that there were more of, this was more of English law of torts that they used to get guided. And one of the famous cases that we all have studied in our college days is Donoghue versus Stevenson, which actually, lays down the principle of care. This is basically the origin of this is in law of torts. Now, some of the legislations that actually govern, this product liability in India are, I have just narrated some of the things, in this. Um, Consumer Protection Act 1986 was there. The Indian Contract Act also deals with the contracts, basically. Sale of Goods Act is there. Drugs and Cosmetics Act is there. Prevention of Food and Adulteration Act, and certain specific statute pertaining to specific goods and standardization. Though these laws touched upon product liability to some extent, like I mentioned before, but it couldn't lay down comprehensive legal framework. So there was no specific, framework, or there was no specific defined liability. There were no definitions of what is a product liability, and there were no mechanisms given, which has now been consolidated, and it has been merged into this new act. So courts used to award compensation. There were some cases here also in India where damages were given, but they were more of punitive in nature, and they were not compensatory as such, because there was no specific provision of product liability. So damages for punishment, or damages for compensation, there are two different aspects to damages. So hence this was lacking. Now, there was this case of Maruti Udyog also, where the court said that the criminal case, or a fraud could be attributed to defective, products that were sold. Obviously, IPC is also attracted when you sell something which is defective, that is the cheating aspect of it, and there are some other legislations also which makes it, which may not deal directly with product liability, but which deals with some other elements of products and goods and especially goods, not the services. So, like, we have the Standard Weight and Measures Act, 1976, where false packaging, weight, or if you even if it is even the MRP is covered under the Standard Weights and Measures Act, basically. So whatever you see, all the descriptions given about the weight, expiry, best before use, if you see all those things, these are all covered in Standard Weight and Measures Act. And any information which is misguiding or false attract criminal offenses under this and under this acts also. So these were some of the acts, which govern. Obviously, when it comes to drugs and pharmaceutical sector, we always had Drugs and Cosmetics Act, which dealt with various drugs. It also deals with medical equipments. It also deals with medical devices. This Drugs and Cosmetics Acts has various schedules under which, there are various medicines which are prescribed and which are given under various schedules. So, there is Food Safety and Standards Commission in India. There is an act to that effect to deal with food standards, where adulterated food and food products are dealt with. Unfortunately, all these authorities are having tremendous shortage of manpower and testing facilities in the country, and these practical difficulties are really not making them ineffective as such. Especially food safety and adulteration is a very big problem. We really have big supermarkets and even reputed branded stores also selling some untested and adulterated products, and there is no way that Food and Safety Authority can actually conduct raids or take samples and do proper testing. So all these aspects were extremely important, and the traditional laws never really took care of it. And like I mentioned before, none of this statute really had any specific provision about product liability. So obviously the need was felt that there needs to be one special provision, or there needs to be some sort of an amendment. So hence the new Consumer Protection Act came into effect. And Further, this act also covers, so the beauty of this act is that it is over and above the other acts, so which means that there is absolutely no, there is, this act has not taken away the powers and jurisdictions given to the authorities under the other acts like standard weight and measures, so or drugs and cosmetics act. So they are completely parallel to this, and they can simultaneously go ahead, and people can use and the an aggrieved consumer can go and take action against any of these acts simultaneously. It doesn't have to be only one at a time. Okay, so what are the contours of product liability? When we say, what are the various angles, or what are the contours, or what are the elements of it? So number one, there has to be a manufacturing defect, or there has to be a design defect. It can also have deviation from manufacturing specifications, not conforming to any warranties, express warranties that are attached with the particular product, failing to contain adequate instructions for correct use, service provided faulty, imperfect, or deficient. So these are some of the contours of product liability. Obviously, the chapter is huge, but these are some of the elements that need to exist before you can actually go ahead and take the action against a company for product for manufacturing defect or anything. So obviously there are some exemptions also under this act. And for example, if a particular good is to be used under a training, so if someone is manufacturing a product for use of which you require a special training, or some sort of a manual is required to actually be studied before you can actually use that product, and if you go ahead and use it without such instructions or without such trainings, then then the damages caused due to such accidents or such products, such actions are not challengeable under this provision. Plus, if the consumer has tampered with the product and because of which it has failed, even such actions cannot be entertained by the courts. So there are a few exceptions, and it is not that manufacturers are going to be held completely responsible for each and everything. Exceptions are always there to the rules, and even in this act there are some exceptions which are very commonsensical exceptions. Okay, now section 84 is a section which deals with what the manufacturing defect or the product liability. So section, as per section 84 of the CPA, a product manufacturer shall be liable. So this is a liability clause if the product contains a manufacturing defect, or the product is defective in design, or there is a deviation from manufacturing specification, product does not conform to the express warranty, or the product fails to contain adequate instructions for correct use to prevent harm, or any warning regarding improper or incorrect usage. So now the point number 5 I feel is very important, because if you see a lot of products in the country right now does not give manuals or does not give proper instructions of use. I have seen so many products which come with bare minimum instructions, and I have also seen some products which come with the address of a website, that if you want to actually see how the product works, you have to go on the website and download the manual, or probably read the manual and then start using it. So that is something which I don't think so can be done now, because a product needs to come with a proper guideline and a manual of using. So if any of the above provisions are prevalent, then I think so the manufacturer is fairly and squarely liable under section 84 of the CPA. So as per section 85, a product service provider shall be liable. Now I'm talking here about service providers. Earlier slide was about manufacturer. Now this is about service provider, where you and me fall under service provider. Okay, the service provider by service provided by him was faulty in quality, nature, or manner of performance. So everything is covered in this one line. I don't think so this line needs any explanation, because quality is definitely of important. So any service provider will now have to ensure that the quality of service that they provide is up to the standard, and I'm sure now there has to be some authority which will set the standards also for various sectors, because when you are actually suing someone for a bad quality or a deficient service, then you need some standard to match that. Okay, so you cannot sue a service provider for a bad service or a deficient service or a bad quality service. Then there has to be some sort of a comparing standard. I think so the next step for the government now would be to actually come out with some sort of a standards. We do have we do have some authorities in India which sets the standards. Quality standards bureau is there in India, but unfortunately it doesn't cover, it doesn't give SOPs, or it doesn't have standards for most of the service providers in the country. I think so that exercise will have to be undertaken eventually. Point number two, there was an act of omission or commission or negligence or conscious withholding of any information which caused the harm. Now, I feel in this point number two, the last line, conscious withholding of information which caused harm, is something which is extremely important for all of us here, because if you are a service provider, then you must give full information to your customer or to your consumer, because this also, if I do a lot of medical negligence cases, and we have a concept of informed consent in medical negligence cases. So even Supreme Court has said way back in 2008 that when a patient goes to a hospital as a consumer, then it is the responsibility of the doctor and the hospital to give each and every information to the patient. So in the medical negligence field, this rule of giving full information has been followed from way back in 2008, where the Supreme Court gave the judgment in Samira Kohli's case. So this is in a way being followed, but it has to be now transferred, and it has to be now followed in the other sectors of the consumer law as well, because more the information, the better the consumer is, and he can make a conscious decision whether to go for that service or product. So hence, according to me, this is going to be a very important part that will define the service sector in the country in future. Point number three, the service provider did not issue adequate instructions or warning to prevent any harm. I think so this is similar to what a manufacturer has to do, give adequate information of pros and cons about the product. For example, I'm doing a case right now in Noida, where a consumer has alleged that a product sold by my client was defective, on the grounds that when she opened the product, it fizzled out and bubbled out and landed up on her hand, and because of that she caused burns. So now that was a chemical. So this is something which is very similar to product liability, but this case has been filed before the lockdown, so we haven't really got to the nitty-gritties of that. But yes, now that this new act is in place, that this provision will definitely come into play, where I will have to see whether my client has given proper instructions of usage or no, whether the storing instructions have been given properly or no, whether you have to store the product at a particular temperature, whether you have to refrigerate it, whether you can store it near the gas. All these aspects have to be taken into account by even the manufacturer and the service provider. The last point, the service did not conform to express warranty or terms or conditions of the contract. So obviously what you promise, you need to deliver. So hence all the service providers and the manufacturers must be now conscious about what claims they make in the advertisement and over the social media about the quality of the product. So hence it is extremely important that they show some sort of a restraint, and they should be now grounded on earth before making any before making any tall claims in the advertisements. More than once we have seen how you get big ads in the newspapers about a particular quality. This happens very often in service sector, where there are guarantees given of a particular treatment or whether a particular product or a service. So hence it is very important that what you advertise, what you promise, what you write in your brochures and your websites is now going to be very important. a lot of work will be generated for we lawyers, because we will have to audit all these things if we have to save our client. So a new area of practice I feel can open up in this sector now. Again, section 86 makes product seller liability of, now this is something which is very new, and I think so that is where the change will happen in this country, because up till now sellers were out of it. The service providers and the manufacturers could be still held liable under some law or the other, but the intermediary sellers were completely could go scot free, because they used to lift their hands and say, we don't manufacture it, ये तो हमारा product है ही नहीं, this is not something that we do, this is not something which we manufacture. But now those days are gone. Section 86 makes it very clear that that a product seller is liable for the product liability claim if it has exercised substantial control over the designing, testing, manufacturing, packaging, or labeling of the product, or it altered or modified the product, and such alteration or modification has substantial factor in causing the harm, or it has made an express warranty which is independent of the warranty made by the manufacturer, and such product failed to conform to such express warranty made by the product seller which caused the harm. Now point number 2 and 3 are very important. As far as point number 2 is concerned, we have a trend in in the automobile sector where there are a lot of service providers who actually take the cars from the manufacturers and they modify the design of the cars, and that is where a lot of people like to have those jazzy looking cars. Okay, so you have this, I don't wish to name any designers, car designers, but you know who I'm speaking of. So at that point of time, if while redesigning that vehicle, for example, if you take a Innova from Toyota, and if that has been converted by some designer, and if they compromise on the safety standards, for example, if they reduce the number of airbags, and if they reduce some sort of safety features, then at that point of time, the such alterations will make that person liable. Okay, so when you actually alter a manufactured product, then it is the person who is altering it which will be held responsible. Now, as far as warranty is concerned, point number 3 is concerned, you have lot of sellers, who, there are a lot of electronic stores, and there are a lot of, people, what you say, departmental stores or retailers are now giving additional warranty over and above the product warranty. Okay, and they take money from you for taking that 2 years additional warranty. Now, if something happens during that additional warranty, now the sellers also will have to be responsible. Obviously, I'm sure as consumerism, as to maintain the standard and to please the consumers, none of these retailers would have gone back on their words. But what I'm trying to tell you is that now there is a specific provision to nail them. Okay, so just in case if you have someone who is selling you an altered product, earlier you couldn't have done much about it, but now there is a specific provision to actually nail them down. So that is where the product sellers are held liable now. The identity of the manufacturer is not known, or if known, the service of notice. I think so. These are the, let's go to the last point that is more important. The product seller has failed to exercise reasonable care in assembling, inspecting, or maintaining the product, or it did not follow the warning or instructions for the product provided by the manufacturer while selling such product, and such failure has proximate cause of harm caused to such product. Now, the word proximate cause is very important while you deal with a case. It cannot be a remote cause, it has to be a proximate cause. So if you're representing a product seller, then what you need to see is basically whether the harm that is caused is proximate to something which he has breached, or if it is a remote cause, then obviously the court will not hold your client responsible. But nevertheless, a reasonable care in assembling, inspecting, and maintaining the product is very important. Lot many times, you have products which come into separate parts, in the knockdown condition or a semi knockdown conditions, and there are some people who only assemble the products here. Okay, so lot many times the stand is taken in the court by people that we don't manufacture it, we only assemble it. Okay, so now that cannot be taken. So if you don't assemble a product properly and if there is a harm, then obviously you will be now held responsible for such acts. Now, e-commerce, like I mentioned in the beginning, was not part of the consumer movement officially before. Though obviously, when you buy something on Amazon or Flipkart or any of the or Snapdeals of the world, you obviously have the receipts. You have made the payment online. You have all the proof. So once you pay something to someone and you buy something, you become a consumer. So obviously, with that logic, you could have gone to the consumer courts even earlier. But now we have a specific section 94 of chapter 8, where e-commerce is now governed by laws that are applicable to direct selling. So which means that online platforms have now been brought in line with offline platform. The guidelines propose that platforms like Amazon, Flipkart, Snapdeal, etc. will have to disclose. Now these are the disclosure norms again. So the reason why this new act is good is because a lot of emphasis is on transparency and disclosure. So now all these online sellers will have to disclose sellers detail, such as their address, website, emails, etc., and other conditions related to refund, exchange, terms of guarantee on their websites to increase transparency. Obviously, it also now the government has also added the country of origin here after the Chinese problem that we had. Now the country of origin also has to be added. So now if you see a product which is sold on Amazon, it also has a country of origin. So you know where the actual product was manufactured. So that is where again this is a transparency to the next level, I feel. So if you don't want to buy a product which is made in a particular country, then that is your personal choice and no one can force you to buy that. The onus of ensuring that no counterfeit products are sold on these platforms will also lie with the company. So now this is something very important. There was a time when we Indians used to be very careful about purchasing products from Amazon or Flipkart or any other online retail, because there was a huge scare of counterfeiting or fake products. Obviously it was not the case. This was just a fear, because I have been using Amazon for a very long time now, right from the days when it used to sell only books. Okay, so since 2002 I have been using Amazon. I never had any counterfeit product come to my house, but nevertheless a lot of people had such experiences. But now it is specifically the liability of these online platforms to ensure that the quality control and the counterfeiting is now stopped, because now they will have to put the check at their end. It is not the onus of the consumer to actually verify whether this is a fake product or whether this is an original product. Now the platforms will have to take that extra step. So which means that they will have to build up compliances at their end, and they will have to put some sort of quality control checks and checks and measures. For example, they will have to now insist on some sort of transparency from the sellers of these products as to the origin or trademarks or copyrights. They need to employ people to actually see whether these products are counterfeit or whether there is any copy of trademarks or copyrights. So this is going to be very complicated for these online platforms, because it's earlier they used to just randomly take some sort of a declaration from a seller, and that used to be it, or some sort of a disclaimer. But now it's not the case. It will have to completely be done by them. So if any such product is reported or recognized, the company could be penalized. The move is this move is fitting, since case of fake products sold through e-commerce platform was very rampant at one point of time. Now, I'm just coming to an formal, just coming to an end. Now, who can file the complaint? An action for product liability claim can be brought by the consumer. Obviously, the person who is the consumer, as defined under the Consumer Act, is someone who can bring the liability. The consumer to whom such goods are sold or delivered, or agreed to be sold or delivered, or such service provider or agreed to be provided, or who alleges unfair trade practice in respect of such good or services. Now, point number 2 in A section is something which needs an attention. It says who alleges unfair trade practices. Okay, so it really doesn't mean that you have to actually be the actual consumer. It could be anyone for that matter. Now the point number B is any recognized consumer association. Now this is this is again something which will give rise to a lot of a lot of activism and lot of check and balances, which probably the consumer associations or NGOs that play in India. Obviously we do have some problems of NGOs, but there are a lot of NGOs and associations or consumer activists who actually contribute immensely in checking the industry and the unfair trade practices that are happening. So now they can officially go and file. They don't have to really prove their locusts, that why are they before the court. They can easily do that. And now central government, the central authority or the state government can also be the complainant. This is something which is new to the consumer forums. In the consumer forums, you never see state as a party. But now the state government can file a complaint for deficient service or product liability against a manufacturer or service provider. This is something which is interesting. Now let's see how the government as a complainant, how much does it make use of this power. One or more consumers, where the number of consumers have the same interest. So this is something where a group of consumers can come together and file an action against a service provider or a manufacturer. So a group action. I don't want to call this as a class action as that in US, but it is definitely a group action which was already done in the consumer forums before. But this power will now, there were some technical issues where consumer courts had held that residents association or cooperative societies or welfare associations didn't have a locus. So there were some judgments, but now with this new provision, the welfare associations or consumer associations or even group of consumers can come together and file if they have the same interest. Okay. The complaint can now institute a complaint within territorial jurisdiction of the commission where the complainant resides or personally works for the gain, and can be filed in writing or electronically. Now this is very important. This is a shift from the original rule where the complaint was filed where the defendant resided or worked or had a place of business. So now this is for the consumer's convenience. Now the new law says that you can file a complaint where you reside. So which means that if your seller or if your service provider is in Delhi and if you are staying in Mumbai, then you can file a complaint within Mumbai where you reside or where you do place of business. So this is a complete paradigm shift in the rule. This is something which is exactly opposite as that of the Civil Procedure Code, where initiation of a suit is defined. It is completely opposite to that, and this is something which is pro consumers. And this one clause is going to definitely have an impact, because if manufacturers or sellers or service providers are spread out across the country, that will involve a lot of traveling for these cases. You will have to engage lawyers in some other parts of the countries, and traveling, staying could be really a logistical nightmare for people. So for this reason alone, I would advise people to be little diligent and be fair to the consumers. If you are dealing in manufacturing products, please be nice to your consumers, because now the consumer in true sense is a king. It's also provide for alternative dispute resolution through mediation. Like I mentioned, most of the product liability cases can go and you can go and mediate before a mediation center, which will be set up. Though the rules are framed, but the mediation centers are yet to start because of the lockdown. Most of the consumer courts are not functioning properly. So once the courts reopen, I'm sure we will have mediation centers attached to most of the consumer courts in the country. As per section 39, where the district commission is set. Okay, now what are the powers of the courts? Now what can a court do? Now this section 39 provides for various measures or various orders that the court can pass. Now earlier, the district forums or the state commission in its original jurisdiction or national commission in its original jurisdiction had very limited powers. Now if you see, lot of powers have been given to all the three district forums, state commission, and national commissions, we can see some of the provisions like obviously to remove the defect pointed out by the appropriate laboratory from the goods in question, to replace goods, or to direct them to give new goods, to return to the complainant the price, or the case may be charges paid, along with the interest, the interest rate can be decided by the court, to pay such amount as may be awarded by the compensation by the consumer for loss or injury suffered. So this power now gives so obviously consumer courts had power to give compensations before also, but this also provides to give compensation towards injury or loss, or of the negligence of the opposite party, provided that the district commission have the power to grant punitive damages in such circumstances as it deem fit. So now there is no, within its powers, the courts can go ahead and grant compensation, obviously to remove defects in goods or deficiency in service in question, to discontinue the unfair trade practice or restrictive trade practice and not to repeat them, not to offer hazardous or unsafe goods for sale. So they can even stop the sale, they can injunct someone from selling a particular product if they find it hazardous, or if they find it unfair or unsafe, to withdraw the hazardous goods from being offered for sale altogether. So these are some of the sweeping powers. They have also power to cease and desist, from offering any services. So the cease and desist power has also been given to the district commission to pay such sum as determined by if it is of opinion that loss or injury has been suffered. So this is again damages power they have, to issue corrective advertisements to neutralize the effect of misleading advertisement. This is basically to educate the people about the true and correct impact of a particular good or a service, to provide adequate cost to parties, to cease and desist from issuing any misleading advertisement. This is something which is sweeping, so I have never seen consumer courts issuing cease and desist orders before, and it remains to be seen as to how the consumer courts will now actually issue, make use of these powers, because in my experience, consumer courts have shied away from using their powers which were given to them even in the earlier act. For some reason, the consumer courts lacked that kind of muscle, more than muscle, lacked that kind of an attitude which actually should be there to protect the interests of the consumers. But nevertheless, now the new act, which is a major step taken by the government of India to prevent exploitation of the interest of the consumers, the courts will now take use of this particular law and try to bring in some sort of discipline and transparency in the industry. So like I mentioned, I started this presentation by saying that Caveat Emptor is a history now. So obviously the popular phrase buyer beware will now be replaced by sellers beware, and or manufacturers beware, as the case may be. So the times change, things change. So now, consumer has really become a king, and the seller, manufacturer, or the service provider has to now have some sort of accountability, transparency, and and discipline. More than anything else, actually what the industry needs is discipline. And with that, I think so I have ended my presentation. So thank you very much for listening to me. I would like to thank my junior Saloni Kedia for helping me with this presentation. Thank you, Saloni, for a wonderful presentation. Now, if there are any questions, I would be happy to take few, or otherwise as the host decides. Thank you.
So I was also going to ask, anybody has any questions? So that I have two. So
okay, please go ahead.
If somebody wants to go before me.
Okay. There is something on the chat. Let me just see what it is. Okay.
Somebody asked, how will quality be determined?
So actually, it's a very good question about the quality, and I think so that is something even which is bothering me as such. And I mentioned in my presentation that when you are actually suing someone for a bad quality, you need to have some comparing quality standards. Unfortunately, Quality Standard Bureau of India is there, but it doesn't have the minimum standards for particular sector or industry. So that is where, to compensate, to complement this new Consumer Act and the new Product Liability law that they have brought in, simultaneously an effort will have to be made to actually fix some sort of a basic quality standards. So I feel that the work towards achieving a optimum justice for consumers is yet to be completed, because manufacturer or a service provider for a deficient quality, but at the same time we don't have any comparing standards. So how would we do that? So that's a question which is even bothering me as such. So I really don't have an answer. Maybe someone else in the audience could have that. But yeah, but right now what happens is that when you don't have a standard, you try to compare it, with the available literature that you have in the public domain. If you have any, if you have any textbooks on the subject, or if you have any, private associations of professionals who have set standards, so such tools can come in little handy. But nevertheless, nothing is good as good as probably an authority laying down some basic standards.
Okay. Um, so there was another question
Yeah.
from Shivangi. Uh, are there some sort of clause service providers should put in agreements now?
Absolutely, I think so, Shivangi. The first clause you should put is now that everything should be subject to the jurisdiction of courts in Mumbai, because because now obviously all the lawyers, we all lawyers do that without fail. I don't mean to say that we don't do it, but I think so. The one problem that we are going to face with this new Consumer Act is the jurisdiction, and I think so. We had written to the government that it should not be like this, because if you have a consumer who has bought a product in Mumbai and if he stays in Assam, then imagine the trouble someone will have to go and defend a case in Assam, because traveling to Assam is going to be such a logistical nightmare. So I feel we have to have our agreements which is very clear, crisp, and we need to actually make the consumer understand exactly what we are providing now, because a vague agreement is not something which is going to help us now, because we need to codify our responsibilities and our qualities. So basically we need to tell in the agreement that this is what you are getting for the money that you are paying me, and nothing is going to be more than this or less than this. So the description of your service or product is going to be very essential. The scope of work that we see in an agreement will have to be properly defined according to me. So we all will have to, including myself, we will all have to work on now codifying and defining how exactly is the consumer, what exactly is consumer going to get from us. So we need to now make a watertight agreement. In short, anything which is vague will not come in handy to us right now. So that is what I feel.
Okay, sir. So Douglas has raised his hand. So
Okay. Hi, Douglas.
Hello. Hi,
Yes.
Amit.
Hi, Douglas.
Oh, okay. My name is Douglas. I'm from Nigeria. My question borders on, because consumer protection, it's quite a novel field in Nigeria. We're just struggling to get it right. Now, you said something. I'm looking at your lecture. I want to know, how would the consumer protection, like the agency responsible for consumer protection in India, how do they stand side by side with other sister agencies? Let's say, for example, like the Food and Drug Administration, the standard organization that will test what will be standard and what will be substandard. How would you put them side by side? Because in Nigeria, they're always at loggerheads with each other. We have like our Food and Drug Administration fighting with the Standard Organization of Nigeria and also fighting with the Consumer Protection Commission. So how does it work in India?
So Food and Drug Administration is an autonomous, body under the, it has its origin in Drugs and Cosmetics Act. Basically, it's an autonomous body. It has got its own powers. It has got its own rules, and So far in India, Douglas, we haven't seen any confrontation between any of the consumer agencies here in India. That's what I said in my last part of my presentation, Douglas. If you remember, I mentioned that the consumer courts in India have really not been so proactive. Even though they had the powers even in the earlier act, but they have not been very confrontational. They have been very docile for that matter, and that is where I feel that the consumer in India also was at big loss, because consumer courts failed in so many fronts. So that's why the situation of having confrontation did not arise. And I'm sure Jamshed will bear with me on this, and if he has anything more to add to this, I would be very happy to hear him also on this point. I haven't seen any confrontation between the FDA here in India and any of the quality standards, because all of them have their own scope, and they have had their own rules and regulations. So right now they are all in the realm of guidelines, Douglas. Okay, so for example, the Quality Standard Bureau we have, though they issue the guidelines, so some of the manufacturing sector has, obviously they have to follow those guidelines, but some of them are not, some sectors are not at all covered. Okay, so that's what I said, that we need to improve a lot on quality standards. We need those standards in writing, and we need those in place immediately if this new act has to come in force. Sometimes confrontation helps, Douglas, according to me, because when two agencies fight with each other, there are a lot of crunching happens, and something proper may come out of it. But unfortunately in India, always on one side. Okay, India is a very unique country, and most of the government agencies always come on one side against a manufacturer. Okay, there will be no government agencies which will take the side of a manufacturer. Okay, so that's why, whether you like it or no, whether the agency is right or wrong, all the government agencies gang up and pounce on the private manufacturer. So that's why there is really no confrontation within intergovernmental agencies, except for what we are seeing now between the Mumbai police and the CBI in one of the popular criminal cases which is happening in the country. But that's also very rare. It's not that every day two government agencies fight between each other. So I don't know, Jamshed, if you have any different experience, maybe you can share it with Douglas. But in my experience, I don't think so I have seen any agencies fighting with each other as such. Yeah.
Jamshed,
So something.
Jamshed has mentioned in the chat that he agrees with you that there could be confrontations between two authorities in future.
Yes, in future, yes, Douglas. And I think so we shall keep you informed the moment we have any.
Does anybody have any other questions? I have to. Okay, I'll take it up. So do you think it would be possible to file e-file a consumer complaint and the court will address it virtually?
So they are working on it. I recently attended a webinar hosted by one of the judges of the National Commission, and they are coming out with a Supreme Court equivalent e-filing system. Now, I'm not very sure whether the Supreme Court system is also the perfect one, but nevertheless, the consumer courts, the National Commission will start taking filing online very soon. And by the time it percolates at the district level, Sudisha, I think so it's going to take some time, because I don't know whether you practice in the consumer forums or no, but the Consumer State Commission here in Mumbai is something which is, in a very shameful condition we are. The infrastructure is not there. I'm not sure even if they start a e-filing, where will they keep the server, because the rooms are not air conditioned. To have a proper server, you need to have that IT infrastructure, which is not there right now. Only National Commission can actually start e-filing immediately, because they do have their standalone building and they have infrastructure. They have a huge building in in Delhi, so that's why there is no space shortage for them there. But here in the district commission and the state commissions, we have a pathetic situation. So I don't see that anytime soon, but they are promising it that it will happen, because Supreme Court is really hammering them that you start e-filing, because there is a lot of pressure from the lawyers to start work now. So that's why the Supreme Court is coming heavily on them to do something. But beyond putting pressure, I don't think so there's anything much happening, Sudisha.
Okay, sir. And so I wanted to know on what's your take on the celebrity endorsement and the liability for an actor or a model endorsing a
So
product
yeah,
under the new act?
this is so this is something which I didn't touch upon, the new Consumer Act. Actually, thanks Sudisha for mentioning this. I really appreciate this point. But this wasn't part of my presentation. I think so. This was indirectly done any which ways. If you see, a lot of celebrities are conscious about the fact that what products they endorse. Okay, but there are some cricketers and there are some celebrities who endorse each and everything. So now I think so they will have to be more careful, because you just can't endorse anything which is harmful, because you cannot use your popular image. So they are influencers, right? You have influencers on Instagram, or you have influencers on Twitter and Facebook. The same way celebrities are influencers. The moment you see a bottle of thumbs up in the hands of XYZ celebrity, obviously thousands of his fans are going to consider, oh my god, it's so macho to drink that thumbs up, where that having one glass of thumbs up will have so much of sugar and calories. So in USA now they are contemplating that there needs to be some sort of a class action against this cola manufacturers, because it has got they have got harmful side effects, and in the long run, having cola or a soda as it is called in US, it's very harmful. Sugar especially, it leads to obesity, and obesity is the biggest cause of deaths in the Western world now. And COVID is also very active when you are obese. So that's why it's all linking up now, and I'm sure you will see a huge class action suit sometimes in future. But nevertheless, celebrities in India, I feel, have been conscious, and I don't think so you will see major celebrities endorsing any cigarette brands or any alcohol brands. So I'm not sure, I haven't come across any popular celebrities endorsing in any even surrogate advertisements for for alcohols or cigarettes. But yeah, but now I think so they were conscious, which is good. Now they will have to be more conscious, because now there is a law to that effect, so you cannot just do anything for money.
Okay, sir. So Tamiz Kumaran sir had a
Yes,
question.
yes. I think so. He has mentioned some valid point. In the absence of infrastructure and adequate measures taken by the state authorities for quality standards, will there be any binding compulsive action to be taken by the government? Actually, this is a very valid question. I'm not sure whether the government can do much about it, because the courts will have to evolve their own mechanism, I feel, in such case, because they may have to probably fall back on some standards of some private institutions. I can give you one parallel example, Mr. Kumaran. Since I do a lot of medical negligence, I keep on going into that, because that takes me to consumer courts almost every day. So basically, in medical, we don't have any standards, but individual associations, there are various medical specialty associations which has their own standards for their own members. Okay, so there is like a gynec association which has got its standards for various gynec related procedures. There is this surgeons associations which have a standard. There is pediatric association. Then there is this Royal College of England and Wales which has got guidelines. Then there is American institutes, various American colleges and institutes which come out with guidelines, right from infertility to obesity and to standard medical practices. So since in India we don't have that, the Clinical Establishment Authority was set up, but it has not gone into detailing of standards. So at that point of time, when there are no Indian standards available to compare, they all see the American standards or foreign standards, basically. So if we don't have any automobile standards, for example, I feel a lot of product liability claims will come to the automobile sector first in this country, because that seems to be the biggest challenge. Because I just recently did a case against a very big foreign company, where a guy was sold a bike which was old. okay, which was almost 2 years old, and now the company is refusing to do anything. So this product liability clause will come in very handy there, but there are no automobile standards, in India, which can be compared or used by the court. So if government steps in is fine, but I'm not sure if the government will ever step in, because the government, I'm not sure, will take the responsibility. So we will have to wait to see how the mechanism develops. And this unfortunate part, Mr. Kumaran, is that this act has now come into force during this lockdown. So not a single case has gone to the court so far. So this is yet to be tested. So I'm sure if I see something happening, I will definitely keep you posted, sir.
Thank you, sir. Anybody has any other questions? I think we can wrap it up. Thank you, sir.
Thank you, Subisha. Thank you, Jamshed. Thank you, everyone. Thank you, Douglas. Thank you, Mr. Kumaran, for patiently listening to me on this lazy Saturday afternoon.
And happy Ganesh Chaturthi, sir, and everybody.
Thank you, everyone. Thank you, my juniors, for attending. Thank you, everyone, for helping. Thank you.
Thank you, sir.
Thank you.
Thank you, sir.
Should I log out, Subisha?
Yes.
Bye-bye. Bye, Jamshed.